Start para. The issue which has been referred to this bench is it mandatory for the magistrate to examine the complainant who has filed complaint under section 138 of Negotiable Instruments Act with affirmation as regards truthfulness of the facts mentioned in the complaint before issue of process under section 200 of CRPC. It so happened that Maharaja Uday Singh Bhosle, son of late Maharaja Pratap Singh Rao Bhosle, resident of Nagpur, filed a complaint in writing on 21/4/2006 against Maharaja Developers and Vijay Dangre under section 138 of the Negotiable Instruments Act on account of dishonor of checks issued by the accused in favor of the complainant and his sister. The said complaint contained a solemn affirmation by the complainant. At the foot of it, the complainant also filed certain documents along with the complainant. On perusal of the complaint and the documents filed with it, the learned magistrate was satisfied that there was prima facie case to proceed against the accused. Hence, by order dated 28/4/2006, he directed issuance of process against the accused under section 204 of CRPC for the offence punishable under section 138 of the NI Act. Para. The accused challenged the order of issuance of process by preferring criminal revision number 624/2006 on the ground, amongst others, that there was no proper enquiry into the complaint as laid down in sections 200 to 202 of CRPC chapter 15 close, that there was no verification of the complaint by the magistrate and the issuance of process was erroneous. The learned third ad hoc additional sessions judge rejected the revision by order dated 24/8/2006, having been aggrieved by the said order. The accused moved an application under section 482 of the CRPC for quashing the complaint as well as the order of the magistrate dated 28/4/2006 for issuance of process and the order of revisional court dated 24/8/2006 rejecting the revision. The said matter was heard by one of us. The learned single judge found that there appears to be conflict of views about the legal position with regard to necessity of recording verification statement of the complainant by the magistrate. Para. When the complaint under section 138 of the NI Act is filed with affirmation in two single bench decisions, Mamta Devi Kumar versus Pushpa Devi Agrawal 2005, it was brought to the notice of the learned single judge that on the basis of the judgment in Mamta Devi's case, the subordinate courts are accepting the affidavits of the complainant in lieu of verification statement and are issuing process against accused. Thus, there would be confusion in the subordinate courts as to what procedure should be followed. In order to avoid further confusion regarding legal position, the reference as above was made to the larger bench. Mr. Manohar, the learned counsel for the accused, submitted that section 190 in chapter 114 of the CRPC deals with the cognizance of offence by magistrate, whereas chapter 15 deals with the procedure to be adopted in case of complaints to magistrates. Section 190 of CRPC mentions three modes of taking cognizance of offence by magistrate. Section 200 of CRPC casts a duty on the magistrate taking cognizance of an offence on complaint to examine upon oath the complainant and the witness present, if any, to reduce the substance of such examination to writing and to sign such substance. Para. The proviso to section 200, however, provides that when a complaint is in writing, the magistrate need not examine the complainant and the witnesses if the complaint is made by a public servant acting or purporting to act in the discharge of his official duties, or by a court, or if the magistrate makes over the case for enquiry or trial to another magistrate. Stop.